that we're celebrating today. Dr. Amodu, are you around?
Sorry, this is Yakubu Belgore. He just left my office. I'm sorry. He's 2 minutes or less to join. Sorry about that. Okay, he's here now.
That's fine. So we will hold you responsible for holding on to our author. Great. We have Dr.
Good afternoon, all.
Good afternoon. I think we have all our speakers on, so we will start because it is 4 o'clock. It's 2 minutes after 4. And so it's my my pleasure to welcome you to SOAS, welcome you to the University of Cape Town, and to welcome you to the book launch this afternoon. I think we already have a program that we have set out, mapped out, but I'm going to quickly tell us the way we would operate today. So if you're not sure whether you're in the right Zoom room, so this particular event is to launch the book that is on corporate social responsibility and law in Africa, written by Theories, Issues, and Practices, written by Dr. Nojeem Amodu. And so that is the event where we're all here for. My name is Dr. Emilia Onyema. I'm a professor of international commercial law here at SOAS, University of London. And I will sort of moderate and anchor the event for us this afternoon. So the way we intend to proceed is, you've seen the little agenda that we have out there. We're hoping that Professor Janet Dine would be able to join us, and so that she can give her opening remarks. She was actually meant to be chairing this event, but she's somewhere really very nice. But not with excellent internet. So we decided not to risk it, and that I would step in for her. I will introduce the book, and I would also introduce the reviewers and our author. We would then go into the reviews. So I'm going to pose 3 questions to our reviewers, and our reviewers would look at different aspects of the book. And so hopefully they are ready. They will speak for 10 minutes each, give us a snapshot of what they think of the particular aspect of the book that they will be speaking to. So first up will be Dr. Femi Amau, then we would have Dr. Lateef, and then we would have Ibukun Iyiola-Omisore. And so once we finish with the 3 of our distinguished speakers, we would then have the publishers. They want to say a few words. As you can imagine, they want to convince you they'll give you some discount so you can buy the book. And so the publishers will come and do their bit, and then we would open it up for Q&A. But for now, if you have any comments, any questions, any interrogations, please use the chat function and add, we can get the discussion going. After that, Dr. Amodu would then give us the vote of thanks, and he would respond to some of the comments by our reviewer and our guests. I will come back and do a closing. So that's the way that's the plan, and hopefully it would go according to plan. So I don't know if Janet is, I'm sure she will try to join us. But for now, I want to quickly speak a little bit to the book. And a few weeks back, I was at an event, an online webinar event, conference where they were talking about corporate law corporate social responsibility. And one of the comments that somebody asked was whether we had any African writers. And because Dr. Amodu had spent some time with us here at SOAS as one of our research associates, I knew about his research. He taught on one of a module that we teach here at SOAS, Law and Development in Africa, that is convened by my colleague, Dr. Olivia here. And one of the things that I quickly raised my hand, as you can imagine, and said, I do know somebody, an African, who teaches and does his research out of UCT, and he works in this area. And I know that a book just came out, so it's great to anchor the launch of the book. So this book, the book we're here to launch, Corporate Social Responsibility and Law in Africa, Theories, Issues, and Practices, is part of Routledge's publications on contemporary Africa. And Nojeem, as you know, some of you might know, some of you might not know, but he's not just an academic. He's an academic and he's also a practitioner. So he works in the field, and that is where we have the issues and practices. So he brings his research and his experience from the field to bear on the book, and that we would see clearly from the book. So he is an academic, he is a practitioner, and as I already mentioned, he spent some time with us as a research associate. He remains affiliated with the University of Cape Town. Nojeem is works currently with Total E&P Nigeria Limited. So some of us, I think he's oozing with oil money. So I can't see his face shining yet, but I'm sure it will soon start shining with the crude oil money from Total. And so the key thing is that would come through from the book when you do read it, and from our reviewers when they then proceed to speak to the book. So I'm going to pause and see if we have Professor Dine around. So what we'll do is we'll carry on, and anytime that Professor Janet Dine joins us, we would give her the opportunity to make her opening, give us some remarks. She wrote the foreword to the book, and the foreword she wrote is actually very interesting. She says things like, I'm going to read a few of what she said, and for those of you who do not know Professor Janet Dine, she's one of the top professors in corporate and company law, international economic law. So she says that Dr. Amodu uses his unique exposure as both an experienced legal attorney in multinational businesses in Africa and a corporate law scholar to conceptually clarify corporate social responsibility as a comprehensive regulatory construct beyond philanthropy, corporate charity, or large companies undertaking community development projects. She says, I'm quoting her directly, she says, the book underscores the pursuit of a corporate law objective to promote aggregate welfare, social efficiency, transparency, and accountability to corporate stakeholders such as employees, host communities, consumers, creditors, the government, and the environment, among others. The book makes a bold and original contribution to the corporate objective discourse by its proposal of an alternative corporate law theory known as the responsible stakeholder model. I mean, that's really huge coming from Janet herself. So these are the things we're going to be, our book launchers would be unpacking for us. So first up is Dr. Femi Amau. Dr. Femi is one of my colleagues here in one of the universities in the UK. So Femi, you're welcome. So Dr. Femi is a reader in law. Some of you might be wondering, what does a reader mean? It's like a senior, almost a senior professor, but you know, we have to distinguish. So Dr. Femi Amau is a reader in law at the Sussex Law School. He is the author of African Union Law, The Emergence of a Sui Generis Legal Order, also published by Routledge in 2019, and Corporate Social Responsibility, Human Rights, and the Law, Multinational Corporations in Developing Countries, published by Routledge as well in 2011. He's helping Routledge make some good money, so that's very good. Dr. Amau, you're most welcome. And so Dr. Amau is going to be speaking to us on the theories, the current state of CSC, corporate social responsibility, as Dr. Amodu has reflected in the book. And then he would unpack for us a little bit the responsible stakeholder model that Dr. Amodu has proposed. So that's what Dr. Amau is going to speak to. And so we start with the huge, the global view, and then Dr. Misbau Alamu Lateef, who is a full-time faculty member at the Faculty of Law, Obafemi Awolowo University. And so those of us who are Nigerians, when we were in our own generation, it was known as University of Ife, yes? And then they sort of decided to cannibalize you guys. Well, anyway, we empathize, but we still remember you as Ife. Anyway, so the Faculty of Law of Obafemi Awolowo University, Ile-Ife, Osun State, Nigeria. And his PhD was on corporate law and governance from the University of Ile-Ife. I'm going to keep calling it Ile-Ife. I think I can exercise that freedom. And his research focuses on corporate law and governance, corporate social responsibility, and sustainable investment. He is presently at the Columbia Law School, Columbia University, New York, as a postdoc visiting scholar. And so Dr. Lateef is going to move over to the regional and give us a regional focus. So an African focus on corporate social responsibility and its regional implementation. So from the global view to the regional, and then the book focuses on two case studies. One is Nigeria, one is South Africa. And so Ibukun will come on board. Ms. Ibukun Iyiola-Omisore is a doctoral researcher at the School of Law, University of Leeds. So she's one of my colleagues here as well in the UK. And she's a graduate teaching assistant at the Center for Business Law and Practice at the university. So she's Nigerian, which is great. It's nice to see another female Nigerian academic. So she obtained her LLB from Nigeria. She's called to the Nigerian bar. She has an LLM in international economic law from University of Warwick. And she is interested in the role of corporate governance and corporate social responsibility in developing economies. So she's going to discuss the corporate social responsibility practices in Nigeria and Southern Africa. And so that's actually the three parts of the book, the theories, issues, and practices. And they might weave into each other, which is perfectly okay. Each speaker has 10 minutes. So I'm going to hand over to Dr. Amau. Dr. Amau, please.
Thank you very much, Professor Onyema. I hope you can see my slides. Thank you.
Yes.
Thank you. I've got a few slides that I'm going to go through as I look at the book. But first of all, let me thank the organizers of this event for inviting me to speak at this event, and also for putting it together, because I think the important thing in all of this is that we are giving voice to the African narrative in different aspects of law, because I think this has been absent in legal discourse. And this day we talk a lot about decolonization. And I think one way by which we can do that is by putting forward the African narrative as it impacts on different area of law. And so I think one of the important things that Dr. Nojeem Amodu has done with this book is to contribute to the putting forward of the African narrative in the context of corporate law, corporate social responsibility, corporate governance, and related issues. So this book itself is a very important contribution to the presentation at a broader level of the African narrative and at a micro level in relation to corporate law, company law, and corporate social responsibility. Now, to contextualize what the book has done, I would say there are several things that the book has touched upon. And these are very important in the discourse around corporate social responsibility. I mean, one of the primary things with corporate social responsibility is trying to find a definition, or what I would call a definitional challenge, when it comes to how we look at corporate social responsibility. Because for most aspects of, say, company corporate law, you have definition of, say, for instance, what is a company in the various company law around the world. But it is not the same with corporate social responsibility, a concept that has developed in more recent times compared to, say, company law itself. So one of the things that Dr. Amodu did in his book was to try to, if you like, contribute to this challenge by trying to give a defined space to corporate social responsibility as a term, and if you like, as that relates to the law. And I think what is connected with that is that when you look at the practice and the discourse around corporate social responsibility, one could categorize it as being unwieldy. It seems to be all over the place. So for example, if you speak to people that are in area of business or business management or in the social sciences, they have a different perspective to how we will see corporate social responsibility in law. And this is due to the fact that the way it is practiced, the way it is defined, the way it is presented differs from place to place, differs from discipline to discipline. And I think another thing that this book has succeeded in doing is to try to bring some level of coherence to what is meant by corporate social responsibility, both in research and also in practice. And one of the key or most important contribution from a legal standpoint is that it's always been a challenge to try to define a role for corporate social responsibility, broadly speaking. And you see a lot of scholars or practitioners saying, oh, well, it's not something that is within the domain of regulation or black letter law or something that should warrant legal intervention. So the challenge has always been there that we need to find a coherent role for law. And when you look at the literature on corporate social responsibility over time, you would have seen things like meta-regulation or reflective law or reflexive law. All of these are attempts to create a role for law within the discourse of corporate social responsibility. And I think, again, one of the strong aspects of this book is to make or to give us, if you like, a coherent and a strong standpoint to make a case to say that the law or regulation or black letter law has a role to play in the definition, practice, and implementation of corporate social responsibility. And of course, I know that the book was written before COVID-19, but I think some of the ideas from that book has given us ways of addressing new developments, new challenges. Because when you see the way companies are responding in this era of COVID is different from the way they would have responded years back. And I think that is because of how, the idea around stakeholders, stakeholder theory, who should be, or what should be the responsibility of companies, which is part of what is at the core of this book. The way it was presented as giving us ideas on how companies should react and how regulators should or interact with companies when new challenges, for example, the pandemic comes up. So from this context, one could say, or from all of these issues, one could say that the book has tried to unpack some of the big challenges in the discourse on corporate social responsibility and give us new insights on how, especially from a legal perspective, how to make it work, how to make it more effective, how to make it more relevant to the society as a whole. Now, just using the definitional issue as an example, as I've said before, when we talk about corporate social responsibility, and here I've likened it to the story of the proverbial blind men who were touching an elephant, and each were asked to describe what they think an elephant is. So if somebody touches the tail, they say, well, I think it's like a rope. Or somebody touches the trunk, they say, well, it looks like a motor or something similar. Or somebody touches the body to say, well, it's so broad and so vast, I cannot even reach from the beginning to the end. So, and the point I'm making here is that corporate social responsibility, depending on the perspective from where a particular researcher is looking at it, is very difficult to describe or define. But in the book, I think Dr. Amodu has taken us beyond that because he's been able to narrow the focus down to certain type of responsibilities and how that responsibility should be dealt with. And I will come back to that in a moment. But again, broadly speaking, I mean, looking at the book, I think the book has done certain remarkable things that I just wanted to point out in brief before I move on to what I think is probably the most important contribution of the book. I'm not going to talk about the focus on Africa, Nigeria and South Africa, which I know that Ms. Iyiola-Omisore will talk about later on, but I think that is important, bringing these ideas, this Pan-African context on corporate law to a global audience through this book. I think is very important. As I've said before, I mean, something that I think is core to what I do as a researcher is this attempt to present an African perspective. I mean, some of you may be aware that I do research around African Union law at the moment. And part of the reason why I've moved in that direction is because I think Africa will have a story to tell. It's not been told properly. We need to broaden that scope. And I think this book, from a corporate law perspective, has done that. It's brought the African perspective on the idea of corporate social responsibility, on stakeholder issues, on the responsibility of the company within society to a global audience, which I think it is remarkable. The book is also set in the context of development, relevant to developing world generally, which I think when we talk about how do we move continents like Africa forward, development is crucial. And the discussion around corporate social responsibility, stakeholder responsibility here is set within that context. Again, significantly, I've said this before, it's a corporate law approach, which is unique. There's not many writing on that from that perspective, especially from Africa. So I think this is quite important. And more significantly is that up until recent times, when we talk about CSR or corporate social responsibility, the dominant voice has always been that it is about philanthropy. It is about company doing something voluntarily. Or if you like, it's about public relations. And I think the core argument of the book, which I think are very, very strong, persuasive, is to move that discussion beyond just saying that CSR is philanthropy or public relation to the domain of law and responsibility and companies taking responsibility for certain things. And it's interesting to note that the discussion up to this point, as I've said before, have not really taken this seriously, but this book have done that. Have taken that seriously to define legal obligations in the context of corporate law for companies. And again, I'm going to come back to responsible stakeholder model. This is an idea that Dr. Amodu has put forward, which I think is quite remarkable and is important in shaping the discussion going forward. There are recommendations in the book in the context of Nigeria, in the context of South Africa, and I think those recommendations are not only relevant to those jurisdictions, they can be extrapolated or applied in similar developing countries. And the book also touched upon the African Continental Free Trade Area context, which for Africa going forward is will be very important. And I'm sure Dr. Lateef will come back to that at a later stage. Now, if I move my slide forward, now, from my perspective, I think probably one of the most important things that this book has done is to put forward this the responsible stakeholder model as a way of looking at corporate social responsibility and issues surrounding corporate social responsibility. Now, especially when you look at the Western perspective or the discourse from a Western country's perspective, the dominant argument has been around, shareholder primacy on the one hand, saying that companies should be run for the benefit only of the shareholders. And that is what you will find in the corporate law, especially in the Commonwealth countries, countries, or the common law countries, so to say, because that is how the law is set up. And then you have on the other side, the stakeholder theories. And these are, if you like, aspirational theories on, we could move away from the shareholder primacy to a stakeholder approach, which look at, take into consideration issues from the perspective of other people that are affected by the operations of the company. I'm mindful of the time, so I'm not going to take too long. So, but what Dr. Amodu has done here is to move that debate beyond that, to say, well, it's not just an argument between these two. There's a way by which we can synthesize or bring these two together in order to move the debate forward. And that is why, his proposal, the responsible stakeholder model, is a fusion, if you like, of these two contesting debates. And in doing so, and I think this is another thing that I found very interesting, that it did not only try to resolve or bring these two ideas together, but it also tried to Africanize, to bring the African perspective into it. So he's on the one hand resolving a debate that has been raging for a long time, especially in the Western world perspective, but also brought into that discourse an attempt to Africanize such laws. And I think this is important in the context of Africa, because most of our domestic laws are borrowed or they're a result of transplantation. So they have a lot in connection with these countries, the Western countries. So bringing the African perspective into it is also quite significant. And what they try to do there, and as I said before, which is very important, is to create legal duty or to identify legal duties that the companies should be held bound to within the context of corporate social responsibility, and to balance that against the interest of various stakeholders. And once that is done, then it is easy then to hold companies accountable to qualified stakeholder as he described it. So if one look at it from that perspective, he has on the one hand pinpoint legal duties for companies, and the other hand also look at ways by which we can identify stakeholders that companies should be responsible to. And I think this is what is at the heart of the responsible stakeholder model that he has proposed, which I think is very important and will be important to policymakers going forward. Just to say on the last note, without taking too much time, is that if one looks around the world, one could see that corporate social responsibility is gradually coming into legislation. And I think some of the ideas proposed by Dr. Amodu down the line, we're going to see this also coming into law in different jurisdictions. I've listed some countries and region where this has happened to some extent in recent times. So this book is an interesting one. It's one that has made a strong argument for the role of law within corporate social responsibility, and has pointed us in directions in which we can take our corporate social responsibility to be more effective and more relevant to society. So thanks for listening.
Thank you very much, Dr. Amao. Before I call on Dr. Lateef, I'm going to ask Professor Dr. Yakubu Belgore, who is the General Counsel of Total Nigeria, to give his few words of remark. Those of us who practice as arbitrators, we always defer to those who make appointments. So Professor Belgore, please.
Thank you very much, Emilia. Good afternoon, everyone. So for me, frankly, and thank you for making me a professor. I'm not there yet, but I do hope one day. So, I mean, I work for Total Energies, and I work with Nojeem, who recently joined our team. He joined us, I think, about on the 4th of August of 2020. And this was at the peak of the pandemic, so we didn't get to see each other, but we did a lot of work online together. The first thing he did for us, we were looking into the new CAMA, Corporate Companies and Allied Matters Act in Nigeria. And it was very extensive review. Normally in-house, we don't get to do so much, but what he did for us was amazing. And so we quickly realized his superpowers as a lawyer. So we now had our own Superman in-house. And what we've realized quickly is his willingness to support everyone else on the team. And strangely, we didn't have to do anything on CSR with him for a while. So I didn't know he had this secret power until he came in to see me on this day, trying to plug his new book, asking me to support. So yes, he was quite convincing, and I was very impressed with the book. I still have it. I haven't read it, but I will very soon. You know, so he made me buy quite a few to spread to our colleagues at work. I was happy to do this because it's good work from a great team member. But of course, I had to seek compensation from Nojeem. So I quickly made sure that he was doing one-on-one regular work on PIB with our corporate social responsibility team in-house, so as to make sure that they're up to speed with the changes being introduced into Nigeria law. So Professor Amao, there's also law being made in Nigeria. So perhaps you update your list for us. What I'd like to say really in conclusion is thank you very much for letting me talk about Nojeem. I'm very proud to work with Nojeem, very happy. And he's been an excellent addition to our team at Total Energies. And I can see him flying a lot over time in his career. Thank you very much, everyone. Thank you.
Thank you very much, Yakubu. That is really, really very encouraging. I think that's the benefit of mixing or joining or linking your academic work with practice. And Nojeem, thank you for making us very proud. So I'm going to ask Dr. Lateef to bring that regional focus to the table and in his own review. Dr. Lateef, please, 10 minutes.
Good morning once again from New York, and welcome to everyone. I'm very pleased to meet all of us here. Professor Onyema, thank you for the introduction. And then Professor Amao, I've read your work, the one particularly on human rights. So I'm very pleased to meet you as well. And of course, I think the proper starting point for me as well is to commend my brother Nojeem for his excellence, and I dare say a most recent authoritative book on CSR and law in Africa. Like Professor Onyema has said earlier, and as emphasized by Dr. Amao, it is a Pan-African representation or presentation, if you like, from the perspective of a scholar who has cultivated his rich experience, from his corporate law practice with business conglomerates in Africa. So he's coming from a background of practice and then combining this with his understanding of the theories, through his writing and then his graduate study. It is not surprising, therefore, that the book is very unique, and it is an excellent contribution to knowledge. The book is divided into 7 chapters of 3 parts. 3 equal parts with seamless, logical, I would say, synchronization of theories, practices, and regulation on CSR in Africa. Although the focus or the author rather choose to focus on South Africa and Nigeria as 2 examples, I do not really think these are representative enough of, the African perspective on CSR. I think more attention could have been focused on other countries, but that is just beside the point. So now, for most part of the last century, as we are all aware, 2 contrasting views of corporate objective have coexisted almost, at a parallel spectrum. And the dominant view, of course, is that expressed first by Adam Smith in his popular publication in 1776, where he talked about the free enterprise, profit maximization, and all of that. And then on to the popular article in the New York Times by Milton Friedman, where he talked about the primary objective of a business being business and to make profit and all of that. But of course, the CSR as we have it in this contemporary time has transcended that shareholder primacy goal. And I think it has now become a global objective. And I doubt if there is any part of the world today or any economy where there is no consensus as to the importance, as to the importance of having a serious agenda, if you like, for CSR implementation. Now, having said that, let me go specifically to part 3 of the book, which the Professor Onyema has asked me to talk about. In this part, what the author does is to bring his originality to bear. First, it discusses CSR together with the associated values and the construct, or within the construct, of sustainable development. It then provides an overview of the African Continental Free Trade Area agreements and interrogates its CSR and sustainable development provisions, measures at the EU, and then juxtaposes CSR against the World Trade Organization agreement and principle. The author tried to explain to us here that although there is this seeming antipathy, regarding CSR in Africa, particularly in Nigeria, where efforts, at maybe legislating a CSR regime has achieved little success. I mean, there have been efforts, at different times to have a primary legislation that will particularly prescribe some of these, CSR values, but then those efforts have not succeeded. And so therefore, what we have in Nigeria presently is more or less an amorphous, code of corporate governance that are dispersed in different secondary legal instruments. But that beside the point. So the author tried to help us understand in this part of the book that the issue of trade liberalization and then the opportunity that it brings to Africa, it's something that can also be achieved or further through an African agenda for CSR, or having a common African principle where the CSR standard and values, can really be entrenched. And then, like the example that you have in the EU, for example. Furthermore, the author makes a case for the mainstreaming, like I said earlier, of a harmonized CSR and sustainable development into the AFTA policy framework, though it laments, the failure of that, agreement, the AFTA, Africa Continental Free Trade Area Agreement, to actually have a serious consideration for the issue of CSR. The author laments this, but then goes ahead to, propose that notwithstanding this failure of the AFTA agreement, for example, it is desirable to have a harmonized CSR within, or as a tool, if you like, to achieve the sustainable development goals and all of that. So finally, I think the author has helped us, like I said earlier, to understand, the preeminence of CSR and the importance of having an African approach to this, which will reflect the values in Africa, and of course, which will also underscore the peculiar legal system in Africa. So to do this further, the author prescribed a model, which Dr. Amao refers to earlier, and he prescribed a model which he calls the responsible stakeholder model. The RSM proposes, for example, an alternative two-leg corporate law theory anchored on a default legal duty to balance the stakeholder interest and a presumption of verifiable corporate responsibility whenever alleged by qualified stakeholder. The author tried to explain this. First, the first leg of the theory imposes a legal obligation on businesses to always identify and balance competing interests of their stakeholder. And I dare say this is where the problem, usually lies. The inability or failure of corporate managers to balance the competing interests of their stakeholders. Of course, there will be diverse stakeholders from one corporation to another. And this is why I think the author specifically used the word qualified stakeholders. So it is the responsibility of each corporation, for example, to identify its own peculiar stakeholder and then find a way of balancing their interests. Then on the second leg of the RSM, the author also imposes a duty, a rebuttable duty, if you like, which imposes a duty on corporations to prove their corporate responsibility, as it were, whenever there is an allegation by a qualified stakeholder that the corporation maybe has committed an infraction of the corporate governance values and the corporate social responsibility. So this therefore makes the RSM an interesting module which transcends existing module by advocating for greater responsibility on the part of corporations. And in his own words, quoting the author now, quote, he said that the RSM, in its explanation of the nature and purpose of companies in the society, is a synthesis of existing assumptions, end of quote, such as the shareholder primacy model, the stakeholder model, state concession theory, and the integrative theory. But much more than a mere synthesis of existing assumptions, the RSM offers a peculiar African prescription, which may be adapted and codified into national laws, as I said earlier, subject to such variations as are suitable to the peculiarity of each country's legal system and history across the African continent. For me, these are the most important original contribution made to knowledge by the author. And of course, in addition to also his prescription of a workable set of model CSR-oriented provisions, for immediate adoption or implementation by policy maker in the African continent. So finally, talking about regionalizing CSR, I think a major challenge which even the African Continental Free Trade Area Agreement is facing now is the seeming fragmented nature of economic blocks in Africa. We have up to 8 of them as we speak now. And even though the membership overlap so that some countries belong to one or two of these regional blocks. But lack of unification or failure to have a unified economic bloc like the EU, which the author referenced in his book, I believe has been a major impediment to a real and true economic integration in Africa. So basically, if Africa will go the way of the EU, or if Africa will achieve the kind of success which the author has advocated in this book, I think one major area to do that is to first have a unified economic regional bloc, not necessarily by suppressing the existing ones, but by having a sort of harmonized, a system to make all of them work together in a way to really achieve the developmental goals and objective of Africa. So finally, again, I commend the author for this wonderful book, which, as I said, has contributed to knowledge. And I, of course, believe that this is going to be a very resourceful tool, not only for academics, but also for legal practitioners, corporate law and governance enthusiasts, and of course, students and policy makers. And I'm sure this has opened, further opportunity to further discourses, in this area of knowledge. So thank you.
Thank you very, very much, Misbau. Thank you. And so I'm going to now call on Ibukun to please zero in on CSR practices in Nigeria and South Africa as the case study. 10 minutes. Thank you.
Thank you so much, Professor Onyema, for that introduction. And it's such an honor to be amongst scholars in my field. And I'm really excited about this book, particularly as it provides an in-depth examination of what is currently happening in Africa, starting from part 3 and part 4 and part 5 as well. So part 4 and 5 talks about CSR in Nigeria, and then part 4 talks about CSR in South Africa. And, one of the good things I like about this book is the fact that, in the situation whereby there are calls for companies to be responsible, not only in Africa, but all over the world, this book is a timely response to that situation, particularly from the African angle, selecting South Africa and Nigeria. And the author, for example, talks about the current state of CSR in Nigeria. And then he highlights the fact that KAMA, literally to a large extent promotes philanthropy, in the sense that KAMA doesn't, have much leverage, to actually ensure that corporations, pay attention to environmental and social issues in corporate decision making, and which is largely responsible for the corporate philanthropy issue, and then also responsible for, development projects. Because over time, when you speak to directors, and some experts in Nigeria, they feel or they believe CSR is just philanthropy. CSR is about community development projects, and this is largely due to the fact that KAMA, hasn't really addressed this particular issue. So companies believe that when they are doing good, they are just engaging in community development project. And then so the author highlights on this fact and mentions that, CSR goes beyond that. It goes to the fact that corporations have to include sustainability issues into the business management, into the DNA of how a company is governed to a large extent. And it's very useful for readers to be, informed about this situation, because, up to date, people, many directors view CSR as philanthropy. And then starting from, and the good news is that the corporate governance codes in Nigeria, the corporate governance of 2018, to a large extent, is ahead of KAMA, in the sense that the corporate governance code highlights the importance of, including sustainability concerns in corporate governance. But unfortunately, this progress has been hindered by the shareholder primacy model, which, like Dr. Amao and Dr. Lateef said earlier, which has been embedded in our corporate law. And, this issue of legal transplantation issues, Nigeria, borrowed from foreign countries and then just incorporated it into our corporate law. So insofar as the corporate governance code is still progressive, the shareholder primacy model embedded in our corporate law, has served as a great hindrance to, incorporating CSR into corporate law. Meanwhile, Nigeria has made attempts to, introduce the CSR bill, which unfortunately, couldn't pass the reading in the Senate. This is due to the fact that, you know, they felt that it was like an additional taxation on companies, for example. Now, if for example, it was in the corporate law, there might have been it might have been a different issue to a large extent, but still the shareholder primacy hinders progress. And then when we're moving to South Africa in part 4 of this book by the author analyzes that, you know, South Africa to a large extent has taken further steps than Nigeria, looking at the movement from the triple bottom line to the triple contest. We can see that South Africa introduced the integrated reporting medium to design to show that, you know, corporations and directors should report on the extent to which they have paid attention to CSR concerns in corporate decision making. Meanwhile, the corporate law again is still shareholder primacy. Now we can see that there's a common problem in this African style in the fact that the corporate governance codes are taking steps to actually recognize the importance of corporate law being a useful tool to promote, to corporate governance codes to be a useful tool to promote CSR. But unfortunately, the corporate law is still behind. So at the end of the day, wherever there's a conflict between the law and the codes, you know, unfortunately, the codes, the corporate law prevails. So I think, you know, like the author has highly addressed that this lack of policy coherence and this issue of legal transplantation has been a serious issue. And to a large extent, with that in place, you know, we can't really achieve sustainability to a large extent. The corporate law has to be addressed. And over time, even not only in Nigeria or South Africa, even all over the world, corporate law has been seen as that holy cow in quote that shouldn't be touched. Meanwhile, other, you know, they're trying to, even the EU has this taxonomy regulation, but still they are not really focusing on corporate law. And at the end of the day, we realize that corporate law gives form, gives effect, you know, to the creation of a company in the first place. So most times, you know, based on the fact that the corporate law hasn't yet addressed these issues, the shareholder primacy model of corporate governance prevails. And I'm really impressed by the author's progressive suggestion in terms of the responsible stakeholder model, in which he argues that, okay, if we can't, because shareholder primacy is to the extreme, in the sense that if we keep focusing on shareholder primacy, then the environment will be destroyed. You know, there will still be huge abuse human rights across the supply chains. So why not we identify some particular stakeholders in corporate governance and ensure that whenever their needs are met, because they are affected directly by the company's impact. So I think the responsible stakeholder model, you know, profiled by the author to a large extent, will go a long way to actually ensure that you know, CSR is embedded into the corporate governance model. And looking at the NATI Act, for example, though is a good sort of hard law, but to a large extent, it hasn't really provided good solution. And even in South Africa as well, they've created this social and ethics committee. Now, in Africa, South Africa is viewed as the first country that has taken steps to, you know, create the social and ethics committee. Now, this ethics committee is headed by the board and to ensure, to kind of monitor how companies engage in sustainability issues, but it is still subject to shareholders' approval. Now, when you're saying that companies should have a social and ethics committee and then still subject to shareholder, you're giving the shareholders powers. And at the end of the day, shareholder primacy prevails. So what the author is trying to argue that is the fact that, you know, we should try and deviate from this shareholder model and not hide under the fact that, okay, the codes are progressing. If the codes are progressing, but then the laws aren't recognizing, you know, CSR, you know, as an effective tool in corporate law, and corporate law is not really strong enough to kick back against, you know, this shareholder primacy, then for a long time, we have a long way to go in terms of enforcing CSR in corporate governance. So I think without this situation, we might not be able to achieve the real aim. So the author, you know, tries to, like, you know, state the state of the current situation in Nigeria and prefers solution through the responsible stakeholder model on how to enforce and ensure that the rights of every stakeholder is important as well. And also in chapter 7 of the book, the author also profiles like a roadmap towards effective implementation of the African continental free trade. Now, the author notes that, you know, when we talk about sustainable development, the author highlights that it was only mentioned once in the Africa Continental Free Trade Agreement. Now, in this kind of situation, you know, although trade is important, trade also helps the economy. But on the other hand, these multinational companies are quite powerful, and they are double standards in the sense that in the developed world, in terms of CSR protection, the developed world have more good structures in place compared to the developing countries. So the author is trying to highlight the fact that the African Continental Free Trade Agreement should highlight the importance of CSR, and not just as a mere lip service, but it should be ensured in the corporate governance and business management of the companies, because we've seen that over time corporations move from they could move from countries to countries looking for a lesser law that is more favorable to their own selfish plans. But if the African Continental Free Trade Agreement has a general law that applies to the 55 members countries, and also highlight the fact that CSR should be implemented in corporate governance, to a large extent that will ensure that CSR is embedded even in the new African free trade agreement. And I think, and to a large extent, if that is incorporated in the agreement, that will go a long way towards enforcing sustainability and to be a right step in the right direction. And the author also draws lessons from the EU. We can see that all over the world, everyone keeps talking about the EU, the EU. This is because the EU has taken steps, although we don't know how effective it will be, but we could see that from their 2020 proposal, from the 2021 proposal, we could see that they also have the EU Sustainable Corporate Governance Initiative as well, which says that directors need to consider environmental issues. And last but not the least, although when Dr. Nojeem, maybe he'll be professor soon, when Dr. Nojeem, highlighted karma and kind of explained karma, afterwards we had the new karma, which amended directors' duties, and the directors' duties says that directors should have regard to environmental issues. Again, the problem is the fact that if you're saying that directors should have regard to environmental issues, and the corporate law itself hasn't provided any means for directors to report on non-financial matters, so at the end of the day, the law is just toothless, because if you're saying directors should have regard to environmental matters, and the same corporate law hasn't made any provision for directors to report on how they have had regard to environmental matters, like it is in the UK in section 172 and section 414 of the UK Constitution, then the new provision, which everyone was excited about, has no impact. So at the end of the day, the author's solution of the responsible stakeholder model can, to a large extent, promote CSR issues and corporate law as a tool to promote CSR as well. Thank you.
Thank you so very, very much, Ibukun. Thank you. So I hear bits about fragmentation of the law, the need for the law that would support the code or the different codes. I think that we can't take the EU out of context and just look at the corporate law or their legal progression. The EU has I think that their integration effort is very, very different from that of the African Union. And I think that's important that we retain that, but that doesn't mean that there isn't something to learn. It's just how do we then implement. I think the point the book makes about the Africa Continental Free Trade Area Agreement as a missed opportunity is really, really an important point. So thank you very, very much. I mean, it's amazing discussion. I'm sure Dr. Amodu knows that you actually read the book, and that is really, really great. So thank you very, very much to our three reviewers. I think at this stage we were meant to do Q&A, but I'm monitoring the chat. We haven't had any major questions, so we're still monitoring the chat. If we do, we will come back. So I'm going to ask Routledge if they want to do their marketing thing now. Helena, go on.
Hello, thank you very much for all of the organizers and the speakers for such an amazing session. I think that everyone watching, including me, is inspired, and I hope that everyone will want to find out more about the book and to tell their friends and colleagues about it as well. I don't want to take any more time because I'm aware that I'm taking time from Dr. Amodu, and he's the most important person here. So I will just leave it by saying that it's been my privilege to work on this book, and to thank Dr. Amodu and everyone who's been involved in this on behalf of Routledge. And I'll leave you with the words of Professor Margaret Akorodudu Fubara, who says that the book is path-breaking, intellectually captivating, and brilliantly constructive. So I think if you weren't already persuaded to find out more, then maybe that does the job. I've left in the chat box some information about ordering the book, and do feel free to contact me if you want any more information. But thank you now, and I'll leave Dr. Amodu to take the floor.
Thank you very much, Helena. And Helena forgot to say that there's a 25% discount. So hurry up, the code for the discount is there. Nojeem, please.
Thank you. Thank you very much. Good afternoon, ladies and gentlemen. It's been a very exciting outing. This is the vote of thanks and the response to some of the comments given. I know we're slightly running, overshooting the time now, so I'll make this as brief as I can. Yeah, this couldn't have happened overnight. Some planning and some great, support for some, it benefited from the dedication of some people that without, them, this wouldn't have happened. Thanks to SOAS School of Law, Professor Onyema, Center for Comparative Law in Africa, CCLA, at the University of Cape Town, Professor Adaodo. Thank you so much. My personal friend Yakubu, Dr. Yakubu. Please accept Dr. Yakubu Naguidi-Sire for the excellent work you've done night and day in the middle of the night. Thank you. I must thank the reviewers. Well, I don't know, short of words, they kind of turn around, they were able to give at a very short notice to deliver on some of these review. I'm very grateful, Dr. Amao, Dr. Lateef, Ms. Iyiola-Omisore, to Professor Dine, who also, unfortunately, fortunately, she's enjoying herself somewhere. I am really grateful. I must also thank my colleagues, current and past in the industry, and Dangote, Waib, and currently at Total Energies. I'm grateful to Dr. Yakubu Begore, Mr. Deshina, Salau, my manager, to Dr. Mr. Kogam, everyone for the support, words of encouragement and guidance. Because, I will soon get to this, there's always that difference between academia, some theoretical aspects and the practical aspects. It's beautiful to be able to combine them, but it's not always very easy. So I'm really grateful to my colleagues. Also, I must mention where this all started. The foundational research for this was as a result of my PhD at UNILAG. So I remain grateful to Professors Abugu and Olawain, Senior Advocates of Nigeria, for their insights. Finally, I can go on and on thanking everyone, but let me just quickly say that in terms of just 2 points for me, the response. Now, what this book has done essentially is to, like Dr. Amao said, to confirm a narrative for corporate social responsibility as conceptualized in Africa. It is to clarify the meaning, the conception of that construct. It is to ensure that, yes, it is important to agree that charity, corporate charity, philanthropy community development project would always constitute, an integral part of what corporate social responsibility is. But the book makes a contribution that corporate social responsibility should not be, given a myopic view, a myopic, construction. It is the same thing all over the world. There is no CSR in the global north. There is no one other CSR in the global south. There is no CSR as conceived in the US, in Germany, and one CSR as conceived in Nigeria and in South Africa. Only one CSR. It is a neutral concept, which means the demonstration of responsibility and accountability in the cause of making profit. The demonstration of responsibility and accountability in the course of making profit or in the course of doing business. So it is usually the issues that would be addressed by different companies that might differ from jurisdiction to jurisdiction. But the core values of corporate social responsibility, they are the same everywhere, whether we're talking about addressing human rights protection, addressing environmental protection, consumer protection, all those, they're all embedded as core values of corporate social responsibilities. But in terms of the issues, while Apple, for instance, elsewhere in the global north could be describing its corporate social responsibility as ensuring that their raw materials as sourced are not, sourced from conflict zones, or they are not adding to some conflict in some part of Africa. That is the concept, that is a subject of responsibility applicable within that jurisdiction. So you see in a jurisdiction such as South Africa, where the subject of corporate social responsibility with the business community and government may be addressing would be trying to address the ills of apartheid, the social exclusion, which has arisen as a result of, the age-long apartheid in South Africa. So you see them bringing up policies addressing, to include the Black community, for instance, to promote such social inclusion. So such will be different from one jurisdiction to the other. So you come to Nigeria also, you will see, the business community and the government trying to address concepts such as, environmental degradation or host community exclusion as a result also of some current issues on ground. But this does not take away the fact that CSR is still the same everywhere. Again, the demonstration, it means the demonstration of responsibility and accountability in the course of making profit or in the course of doing business, which leads me to the second concluding remarks. And that is that the proposal made by this book called the Responsible Stakeholder Model, a little clarification. As Dr. Amao and all other reviewers mentioned, it is not, it's not in any way suggesting that we should throw away everything about some assumptions in shareholder primacy, for instance, as predominant almost everywhere in the world. Because we need to realize that businesses exist primarily for profit making. They exist to make profit. However, there must be a demonstration of responsibility in the course of profit making. It cannot be profit making at all costs. This is where corporate social responsibility comes in, and this is where RSM comes in. So we must, operate from that background that if businessmen don't invest their money into businesses to make profit, where there won't be companies in the first place. There won't be corporations anywhere in the world. And we can only imagine the amount of contributions, the values which corporations have added all over the world. Without them, probably what we are wearing wouldn't have been produced in the first place. But we just need to ensure that we create an enabling environment for businesses to thrive, but responsibly. With these few words, I thank once again everyone, our valued most valued invited guests and everyone who was, participated in this launch. I thank you for joining us, and I hope and I look forward to continue this conversation even beyond this platform in terms of further engagement with corporate social responsibility at research and practice levels. Thank you very much.
Nojeem, thank you so very, 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 very much. Thank you. We are very grateful. All I'm hearing is that it's really echoing what Janet Dine concluded in her in her foreword to the book. She says the book is unique and timely. I think we all agree with that conclusion, and that's what the reviewers have said. I can see Ada Odo nodding her head, so which means we're in the right path, is to say a huge thank you. Thank you for the opportunity that you've given to SOAS to support this event. And so with that, we say thank you again and have a very lovely morning, afternoon, evening. Don't forget to order the book. That is where that's how his brain will start shining a little bit more with the oil money. So it's important to get copies of the book, get your libraries to get copies of the book and read the book. And most likely the way Dr. Amao is nodding, I think we're going to have another event around the questions raised by the book. So thank you very much. And I would say bye-bye to everybody. Thank you. Bye.
Thank you and bye.